Following the delivery of the majority judgment on the 20th of September 2017, a judgment which annulled the outcome of the presidential election held on the 8th of August 2017, and which decreed that the election be repeated within a period of 60 days, the chairman of the Independent Electoral and Boundaries Commission returned to the court with a motion seeking clarification of an aspect of the task assigned to him by the wording of the said judgment. The Constitution of Kenya 2010, Article 163, Sub-Article 2, provides that, quote, the Supreme Court shall be properly constituted for purposes of its proceedings if it is composed of 5 judges, end of quote. At the hearing of the notice of motion, which related to a final judgment issuing forth from the court, I was part of the quorum setting, notwithstanding that I had delivered a detailed dissenting judgment on the 20th of September 2017. Having been fully involved in the hearing of the notice of motion, I now have the obligation to render a separate opinion which properly reflects my viewpoint as a judge. However, upon considering the tenor and effect of the majority's position in this ruling on jurisdiction and related elements, I find myself in agreement with the overall outcome in that regard. Hence, this opinion, which nonetheless takes a differing course of explication. The majority judgment embodied the declaration that, quote, the presidential election held on the 8th of August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared result by the IEBC chairman invalid, null and void, end of quote. Being concerned to fully comply with the majority's terms in the conduct of elections again, the second respondent moved the court to make an appropriate clarification on the following points. Point number 1, is it the ballot figures recorded in Forms 34B submitted by the constituency returning officers to the National Tallying Center, or the ballot figures recorded on Forms 34A from individual polling stations that must be used in declaring the presidential election results? And secondly, how ought the respondents to proceed in ascertaining the vote tallies where discrepancies are found between the two sets of forms, that is 34A and 34B? The two questions arose not only because the majority decision had left them open, but in particular because that decision had upheld an earlier Court of Appeal decision, Independent Electoral and Boundaries Commission against Maina Kiai and 5 others, Civil Appeal number 105 of 2017, to the effect that the second respondent may not correct, vary, confirm, alter, modify, or adjust the results transmitted from the Constituency Tallying Center to the National Tallying Center. The effect being that the results declared by the constituency returning officer were final as far as the National Tallying Center was concerned. Notwithstanding such a prescription in the Maina Kiai case, the majority judgment had required a verification of votes cast by the respondents, and this would entail an arithmetical process. The applicant states that the judgment of the 20th of September 2017 does not signal the obligation required of the respondents if, upon verification, they find that the vote count recorded on the basis of Forms 34B does not conform to that captured in Forms 34A. The applicant's motion is brought in the context of Articles 138, 163, 159 of the Constitution, Section 21(4) of the Supreme Court Act 2011, and Rule 3245 of the Supreme Court Rules 2012. Article 138 of the Constitution relates to the procedure applicable to presidential election. Article 163 provides for the establishment and jurisdiction of the Supreme Court. And Article 159 gives broad directions on the reaches of judicial authority. Questions of jurisdiction against such a background are to be seen in relation to the terms of Section 21(4) of the Supreme Court Act, which thus provides, quote, within 14 days of delivery of its judgment, ruling or order, the court may, on his own motion or on application by any party with notice to the other or others, correct any oversight or clerical error of computation or other error apparent on such judgment, ruling or order, and such correction shall constitute part of the judgment, ruling, or order of the court, end of quote. The one case that has considered the Supreme Court's special jurisdiction under the Constitution of Kenya 2010 is Honorable Lemanken Aramat against Arun Maita May, Lempaka, and two others, petition number 5 of 2014, and paragraph 101 of that decision reads as follows, quote, we would make it clear in the instant case that it is a responsibility vested in the Supreme Court to interpret the Constitution with finality. And this remit entails that this court determines appropriately those situations in which it ought to resolve the questions coming up before it, in particular, where these have a direct bearing on the interpretation and application of the Constitution. Besides, as the Supreme Court carries the overall responsibility, Articles 163(7), for providing guidance on matters of law for the state's judicial branch, it follows that its jurisdiction is an enlarged one, enabling it in all situations in which it has been duly moved to settle the law for the guidance of other courts, end of quote. The questions arising in the instant application speak for themselves, and I have no doubt that the court ought to have spoken with distinct clarity if indeed the respondents were ever to discharge the obligations placed upon them. The court's jurisdiction, therefore, in entertaining the application is beyond doubt. From the submissions made by counsel, it is apparent that the several sets of forms used in the collation and expression of vote count are not always consistent, and so may pose challenges to the respondent's task of accurate accounting. In the main ruling of this court on this occasion, it is stated that, quote, it is therefore the duty of the second respondent to bring to the attention of the public any inaccuracies discovered by the verification, even as he declares the results as generated in Forms 34B. The effect of such inaccuracies on an election depends on their gravity or otherwise, end of quote. Forms 34B as a basis of declaration of vote outcome, in my view, is practically sound. However, given the vitality of finality in electoral processes, the second respondent ought to take responsibility for assessing in the first place the relevance of any discrepancy in the recorded details to the electoral result. On that basis, the result should be declared, save that an aggrieved party may move the Supreme Court on the basis of clear evidence pointing towards a differing course. Such a position may well qualify the principle in the minor KI case, and this would be entirely in order, given the Supreme Court's stature by the terms of Article 163(7) of the Constitution, which says, quote, all courts other than the Supreme Court are bound by the decisions of the Supreme Court, end of quote. Now, this opinion represents my perception on the issues brought before this court by the applicants. And on the basis of its standpoints, and in particular as regards the Supreme Court's jurisdiction, I am in accord with the majority ruling. That is the decision that I wanted to render as my separate opinion.
Thank you, my brother judge. That marks the end of the delivery. And unless we have anything else, we shall adjourn.
Much obliged. We take this opportunity once again to thank the Supreme Court for helping clarify the law and the manner in which the proceedings were handled accord with the dignity of a Supreme Court of the Republic of Kenya. Thank you.
We thank you, Counsel.
All right.
Naam, mtazamaji